Shall we invite the representatives from Jockey Club to come in so that we can start the discussion of the second item? I think we have to press ahead for time. At the previous meeting, members raised several concerns requiring the administration and the Jockey Club to give written reply. And members can refer to CB bracket 2 1174/1213 bracket 18 for the list of follow-up actions. For the replies from the administration and Jockey Club, they are CB 2 1174/1213 bracket 19 and bracket 20, respectively. Deputy Secretary, will you take us through the reply of the administration? May I defer to the Inland Revenue Department to talk about the 2 points about the taxation, and then I can take up on the other parts. Can I start now? Yes, please. Paper CB 2 1174/1213 bracket 19, that's the written reply from the administration to the Bills Committee. I would like to draw members' attention to paragraph 1, which is about whether a 3-year guarantee period is reasonable. As said last time, the guarantee period was set down on the basis of the turnover in the previous 3 years. Why 3 years? We made reference to the betting duty ordinance amendment in 2006. At that time, we also used the 3-year guarantee period. We don't want any loss of government's revenue because of the amendments, and so we put forward the 3-year guarantee period. That was what we did last time, and we set down the same policy this time. In fact, you talked about it at the previous meeting. Any supplement from the government? If not, let's see if the Jockey Club has any supplement. Chairman, I'll be brief. Last time, we were asked about the anticipated turnover. We already mentioned in the paper that that's way below the tax band, the first tax band. It's very unlikely that we will exceed the tax band. And we also explain the criteria of selecting overseas races. It's not that we look at the financial side only. We rather look at which races Hong Kong horses take part in and the quality of the races. This is an era of the internet, and things are moving rapidly. So we think the 3-year guarantee period is sufficient, is reasonable. As for the royalty fees, if it's above 1.5%, what are the implications on the duty? For the races in Dubai, Japan, and the US, because of various reasons, overseas bettors cannot bet on Hong Kong races. And without the tax deduction, we have to bear in mind that the duty in Hong Kong is rather high, and we may encounter difficulties in operation. and we may have to end our service in that regard, and that will give way to arbitrage, and that will not affect the Hong Kong Jockey Club. Did you hear the deputations? Did you listen to them? Did you know their concerns? I don't know whether you want to reply now or will you give a written reply later. Yes, we heard them. For some of the concerns, they are really some very broad issues that we can't deal with. What about your staff? About operation and our employees for the roster, we have very concrete data to base on when we come up with the roster. Average time of each race is 30 minutes. So after a race, normally people do not place bets. So it's only about 60% of our staff have to, or in fact, 60% of the time, the staff will have to pick up the phones, and then the rest of the time, they just have to wait. They don't have to pick up calls. There are some misunderstandings in the operation for fixed odds. They cannot go into, they should not be mixed with commingling. Say that going commingling will push up the bets, will push up the receipts. That's not correct. I don't know whether I got your employees right, but just now he said he is worried that with the amendment, there will be a need for enlarging the workforce. And then will there be an increase in workload with the increased? Will there be an increase in workload? That's not directly related to the commingling, but with more workload, we will enlarge our workforce. Will it increase the workload of your employees with commingling? For local bettors, betting on overseas races, there will be fixed odds. There will not be any chance for arbitrage. We do not expect a drastic increase in workload, and if necessary, we will appropriately increase the workforce. Any questions from members? 5 minutes each. First, Mr. Wu Chi-wai. Thank you, Chairman. Just now, you also raised the complaints and concerns of the staffers of Jockey Club. Some deputations submitted written submission but have not attended the meeting. And we have one part-time telebet staffer saying that according to the contract he cannot do other jobs, but there is no subsidies for medical treatment and for lunch and other benefits for him. This may not be directly related to the amendment, but since it's raised, I don't know whether this will be dealt with here, but maybe that will be dealt with separately. You asked the question already. Let's see if the Jockey Club can give us any reply. Yes, it's not directly related to the amendment. But one deputation already said that commingling may increase workload. That's why I would like to see if the Jockey Club can reply. This is a contract between the Jockey Club and its employees, not directly related to commingling. But Mr. Mack, can you give us a quick response here? For our contract staff, There is no condition saying that they cannot take a part-time job in other organizations. What about full-time staff? I understand that you cannot bar part-timers from doing part-time job. Now, for full-time workers, if they want to take a part-time job, they have to notify us to wait for our approval. Any follow-up question, Mr. Wuchiwai? Thank you, Chairman. I want to follow up on points raised by deputations about pools with possible jackpot. It's not going to be included in commingling, right? With a larger pool, say like pools with possible jackpot, we will create a talking point in the city, and people will try their luck with this introduction. So this is my question. Are they related? And my second question, Jockey Club said that under the gambling ordinance, there may be fixed odds for certain races. If that's the case, is it related to overseas races too? Who's going to take up the question, Mr. Chen or Mr. Mack? About the tradition and the environment overseas, they are different from locals, depending on the preference of bettors. Exotic pools are actually very small. As for whether commingling and fixed odds will go together, will we cooperate with overseas organizations? In fact, it is not related to commingling. They're two different matters. Sorry, can I follow up on that? I did not quite get it. According to the deputation, with commingling, the pool will be larger. Now, in the past, some of the bets go into pools with possible jackpot. Which is in effect a larger pool. For non-standard pools overseas, we're not talking about a lot of it, so we don't expect a large amount of such pools to be imported to Hong Kong. Are there any races involving pools with possible jackpots? I mean, concerning overseas races. At present, no. No, because we haven't introduced commingling. But say, for example, about the king of the jockeys. Can Singaporean jockeys come to Hong Kong? Can the pools be introduced to Hong Kong? First four plays and win, we have that in Hong Kong, but not overseas. So what will happen? The question here is not about how much money you attract and whether that will change the payout. Not that.
First of all, commingled pools, they have the same pool and the same payoff. For fixed bets, fixed payoff, such as Jockey King, basically in Hong Kong, the Jockey Club has a betting transaction with its clients. For overseas fixed payoff, they cannot mix. It's like soccer, where you receive a bet, and if you want to place a bet on with another bookmaker, it's arbitrage. So this is not related to the commingled pool. The commingled pool have the same pool and the same payoff. What about in the double trio? They have the same pool, same payoff. In principle, in our commingled pool, they have pools. Both parties have pools. Let's say if they don't have a double trio, we cannot have outbound and we cannot have inbound because we don't have a double trio. But for tiers, if both events have tiers, then we can commingle. And when we commingle, it has to be in compliance with the betting regulations. So let's say they have 6 up. Let's say if they have different races, if they have a race 1, 2, 3, 4, 5, 6, and we have in a race 5, 6, 7, 8, 9, and so they cannot commingle. So it's a very limited in very select pools. The mainstream events are in the win pool. All the arbitrage events occur in the win pool. So, of course, the win will give rise to quinella and other pools. The exotic pools have a lower probability of commingling. To use Hong Kong as an example, the special pools make up less than 15% of the total pool. And overseas jurisdictions, the interest in exotic pools are about 10%. So they are not mainstream pools. Any follow-up? No? Do we have any legislators with questions? So can I assume that you have already clarified your questions from the Jockey Club and the administration? If so, we can answer clause by clause. So, Secretary, you can lead us. Would you like Winnie to lead us? Are we referring to the marked up copy? Well, it depends on which you find convenient. I will be referring to the page numbers, C838 and so on. Okay, Chairman. So we are dealing with Betting Duty Amendment Bill 2013. We have to amend the Betting Duty Ordinance. And there are two major goals. And the goals are reflected in the long title. The aim is to abolish the duty for bets accepted outside Hong Kong in relation to the conduct of authorized betting on horse races. This is in line with levying at source. And the second aim is to charge a duty at a flat rate on the net stake receipts derived from the conduct of authorized betting on horse races held outside Hong Kong. In the previous committee meeting, we had taken note that the second purpose will allow the Jockey Club in negotiating outbound commingling have a clearer stance. So these are reflected in the long title. The bill has 3 parts. So if you allow me, we don't have any questions, so you can proceed. Part 1 is the preliminary. We have the short title and commencement. Now, assuming it is endorsed by LegCo, then it will take effect, it will come into operation on 1st September 2013. And the date is set in 1(2). On page C842, we have Part 2. Part 2 has the different amendment details. And Section 3 to 17 lists all the amendments. We now refer to Section 3 and 4. 3 and 4 amend Section 1A and Section 6GA. The amendments include addition of new definitions. These new definitions they clarify the terms, and I'd like to refer you to 3(8), that is C844, (8) on page C844. We have definition, interpretation for local horse race. And at the same time, we have introduced another definition, that is non-local horse race, which means a horse race held outside Hong Kong. These 2 new definitions will be the terms used after the amendment, so therefore we need to have a new definition. Next, we move on to page or Section 5 on page C848. Section 5 repeals Section 6GC. The reason for repealing that is because in the new commingled pool arrangement, the government will not levy betting duty on overseas races. So we do not need the overseas betting or receiving of bets. So we don't, in other words, we don't need Section 6GC. Next, Section 6, it amends Section 6GD. 6GD deals with horse race betting duty, and you refer to 6 bracket 1 and 6 bracket 2. 6 bracket 1 and 2, they amend 6 GD bracket 1 such that the tax rate will only apply to local races and local bets gross receipts. Next, we move on to 6 bracket 3. This part repeals 6 GD bracket 2 and 6 GD bracket 3. This repeals the overseas bets received and the tax received on these overseas bets. Moving on to 6 bracket 4. Adds a new section before 6 GD bracket 4. We now add 6 GD 3A. The purpose is to have when we have overseas races, a duty is charged at the rate specified in Schedule 3, and this duty is specified in Schedule 3, a new schedule. And Schedule 3 will provide this standard uniform duty. The duty will be charged on the net stake receipts that are derived from the conduct of authorized betting on non-local horse races. Moving on to page C850. Please refer to 6 bracket 6 and 8, bracket 8. 6 bracket 6 and 6 bracket 8 repeal the existing 6 GD subsection bracket 5 and subsection bracket 7 bracket 8. The reason for repealing these is in the new commingled pool arrangement, the government does not need to levy a duty for overseas races, so all these will not be applicable, and therefore they need to be repealed. Moving on to Clause 7. This repeals Section 6GE. The existing 6GE has already expired because 6GE it's related to the 3-year guarantee period in the Betting Duty Amendment Bill 2006. When the Amendment Bill 2006 3-year guarantee period was approved, it had already expired on 30th of August 2009. So the current 6GE has expired. So therefore, we need to repeal that in Clause 7.
第8條呢係
Clause 8. Addition of a new section, that is Section 6GEA. The purpose of the addition is to set down the circumstances when a horse racing operator in Hong Kong has to pay the guarantee amount. Under the 6GEA, it stipulates that the guaranteed amount for a wholly relevant charging period exceeds the horse race betting duty charged under this section on the net stake receipts that are derived from the conduct of authorized betting on non-local horse races by the specified horse race betting conductor in respect of the charged period. Then he should pay the relevant amount. Coming to Clause 9. It amends Section 6GF in the ordinance, which is about the calculation of net stake receipts. With the amendment, we set down new provisions on local bets on overseas horse races, and how we come about the calculation of net stake receipts concerning such bets. I'm afraid I have to go into details here. I have 3 points to make about Clause 9. First of all, it is an amendment of Section 6GF bracket 1. It is about the calculation of net stake receipts. After the amendment, the said section the formula in the section will only be applicable on local bets on local horse races. Part 2. Is an addition of 6GF1 bracket 1A. The net stake receipts that are derived from the conduct of authorized betting on non-local horse races by a horse race betting conductor in respect of a charging period are calculated by using a certain formula. So the previous one is about local bets on local races, and for bracket 1A is about local bets on overseas races and how we can calculate the net stake receipts of that. The formula is on page C855 English version. After the addition of bracket 1A, the formula goes L minus M minus N. Definitions of LMN are already specified in the clause. L represents local bets, total local bets on overseas races. that's L, and it's relevant to the charging period. L minus M minus N, and M represents the total amount of dividends and of rebates on bets that have become payable on non-local horse races by the conductor, and N represents the aggregate of the extra amount payable by the conductor for each bet type in a non-local horse race on which authorized betting is conducted by the conductor within that charging period. Once again, let me repeat. The formula involves calculation of net stake receipts, and by that we mean the local bets on overseas horse races, and the formula goes L minus M minus N. That means the total amount of bets minus the total amount of dividends and of rebates on bets to be paid to non-local horse races by the conductor, and minus the aggregate of the extra amount payable by the conductor. And the last part on clause 9 takes us to C857 English version. We have definition of specified amount and extra amount, and also specified payee. These definitions are related to L at the end. They are about the, now for the specified amount, when it comes to commingling, a local operator has to get information about the overseas horse race that covers sounds or visual images or any information related to the race, say the type on the race by the horse race betting, say like the odds on a certain horse. So for specified amount, bracket A, bracket 1 and 2, and bracket B are actually about the sounds, visual images related to the race or both, or any information related to the overseas race. Or any information related to the race other than in the form of sounds or visual images, and the amount payable to the specified payee for the right to conduct in Hong Kong the betting of that type of the race. All this goes under specified amount. After the specified amount is paid, and that the amount exceeds 1.5% of the total amount of bets of that type, then the excessive amount comes under extra amount. Which also comes under the clause. For extra amount, it can be taken away from the net stakes receipts. As stated, extra amount in relation to a bet type in a non-local horse race means the portion of the specified amount for the bet type payable by the horse race betting conductor. That exceeds 1.5% of the total amount of bets of that type. That can be deducted from in the calculation of the net stakes receipts. Moving on to clause 10. It repeals section 6GG of the ordinance. The existing section 6GG is related to the Betting Duty Amendment Bill 2006. In particular, the 3-year guarantee period, but the period already expires on the 31st August 2009. That's why we have to repeal 6GG. Next, page C659, clause 11. Which is about the addition of section 6GGA to the ordinance. Now for 6GGA, it is the guaranteed amount for non-local horse races. That is $175 million. There is a formula in the section to tell you how we come about with the figure. $175 million times number of relevant days in the charging period over 365. Clause 12. Which is to amend section 6GI of the ordinance. The clause is to repeal or 2B3 This is a corresponding amendment. And then page C860, clause 13. Repeals subsection 7 of section 6GN, which is about assessment and holding over of duty. But in fact, clause 5 already proposes repealing 6GC. So this is also a corresponding amendment. Clause 14, to repeal Section 6GP. This section is similar to 6GG in the sense that they are related to the amendment in 2006. In particular, the 3-year guarantee period, but the period already came to an end on the 31st of August 2009. That's why 6GP is no longer effective. That's why we propose to repeal it.
Moving on to page C862, Clause 15. Clause 15 amends Schedule 1. After amendment, the rate of duty will only be applied to net stake receipts from local horse races. Clause 16 repeals the original Schedule 2. In the original Schedule 2, regarding overseas bets on local horse races, there was a duty, but this bill will not charge a duty on overseas bets on local horse races. So the discount rate will not be applicable. So therefore, Clause 16 will repeal Schedule 2. Just now I mentioned there are 3 parts to the bill, and Clause 17 is the last part in Part 2. In Clause 17, we have a new schedule. It will be Schedule 3. The purpose of Schedule 3 is to describe a standard tax rate of 72.5%. 72.5% will only apply to local bets on overseas horse races, and it will be applied to the net stake receipts. So that we have dealt with Part 1 and 2. Next, we move on to Part 3. Part 3 is also the last part, and it is to be found on page C864. Part 3 it deals with subsidiary legislation Cap 108, and Clause 19 deals with the betting regulation amendments. The horse racing operator has to make submission of returns to the Commissioner for Stamp Duty, and we will be repealing 3AA bracket 3B and 3AA bracket 3 bracket 5. And this is to deal with the 3-year guarantee period, which has expired on 31st of August 2009, and therefore we need to repeal these. I have concluded my clause-by-clause scrutiny. If members have any questions, my colleagues from Tax, Inland Revenue, and DOJ can respond. Mr. Allen Lau. 6GF bracket A. Where do we find the extra amount, specified payee? Where do we find these defined terms? The page C856, the Chinese version, C856, lists specified payee chairman. The specified payee, specified amount, and extra amount should be found in the new one, capital A, but I can't find it. (6GF1A). There's an N. N has extra amount. The extra amount is defined, but this is a complex concept. It refers to a specified amount. And since it's so complex, we have to define specified amount. And in specified amount, we also have to define specified payee. In brackets lowercase a, we refer to amount payable to specified payee. And therefore, you have to read all three paragraphs together. It's part of the previous definition. So, in the last definition, specified payee, in Chinese, it refers to Mao Kun Lei. Is that a general description, or do we have a specific interpretation? Allow me to specified payee occurs in the definition of specified amount, and the specified payee occurs in paragraphs lowercase a and b. In paragraph A,
for the right to use 就係講緊呢個 right 咯。B 段咧就係話 the amount payable to the specified payee for the right to conduct， 亦要講 B 段個 right 係講緊呢兩個 right 嘅，喺民意度講呢兩個 right 嘅。所以 in relation to a right 就係想講緊呢民意呢兩個權利，就唔係泛指。
So it refers to these two rights, not a general right. Well, of course, Mr. Pang is the expert. So this type of drafting uses the latter definition to this type of arrangement. Is it normal? So are you trying to say that can we have the definitions in one sentence? That would be very clumsy, so we would separate them. It's not that common, but when we come across this situation, we just break it down to simplify it. So if you look at the English version, it makes logical sense, because you start with extra amount, and it needs to explain specified amount, the next one, and in specified amount, it refers to specified payee, and in the following definition it is explained, but it's in the reverse order in Chinese. Of course I understand, because in Chinese it's counted by the number of strokes in the character. Yes, I understand the objective need, but if you assume the person doesn't read English and he wouldn't understand the logic, all of a sudden there is a specified payee, where in fact the extra amount should occur first. You would follow the definition of specified amount and then specified payee. So how should we handle this order, the Chinese order, for people who only read Chinese? Yes, I also find it strange. It's very rare where we see the Chinese version listing it in the reverse order of the English. We always find the Chinese translation difficult, and here we have extra amount, specified payee, where in the Chinese it's in the reverse order, where specified payee comes first, specified amount next, and extra amount last. In the English version, according to our drafting practice, it comes in alphabetical order. Extra amount, specified amount, where in Chinese it is listed in stroke order, and we also have the brackets with the English term. It's not in the chronological order, in order that they appear, and since the three terms are not a lot, we see in 1A there is the extra amount appearing, and therefore we can, and on the next page we can find the definition of extra amount. I think I can deal with the problem. Yes, I said I understand why it is in such an order, because in Chinese it's according to a number of strokes, and in English it's according to alphabetical order. But the question is, the English is in sequential order. There is a logic behind it. At first it was because of unfamiliarity. For example, specified amount is lifted from a part of the extra amount, and specified payee comes from a part in specified amount. Of course, I understand. In Chinese, the order is according to number of strokes, but in this complex case, a very rare concept, shouldn't we have a special arrangement? That's what I'm considering. Of course, I'm aware Mr. Pang is answering my question, but I'm saying, since the logical order comes from extra amount and specified amount and finally specified payee, so let's assume a Chinese reader who only reads Chinese, to take care of his logical needs, shouldn't you have it in the same order as the English version, even though it would be against the normal order of number of brushstrokes in Chinese? Yes, you referred to the two official language drafting arrangements. So perhaps we can provide a written reply later. This is just limited to 6GF1A L-M-N in 1 capital B. It just deals with 6GF bracket 3 bracket capital A. So if you're just limited to 6GF3, then I do not feel we need to insist on having Chinese brushstroke order.
因為
Mr. Pang, a preliminary view is that we're not talking about a lot of definitions. If we're talking about definitions of 7-8 terms, that may be a different case. But we're just talking about 3 definitions. I don't think people will have a hard time to locate them, but we will supply a written reply to Mr. Leung. Any questions from members? Mr. Liu. Our meeting actually should end at 6:30, but we start 10 minutes later than scheduled, so we can end at 6:40. So what is it then? I'm just reminding you about the time. All right, please get on with your question. Can we end this today? I don't know. You tell me. You tell me. My question is this. There is nothing in particular about outbound commingling. So, if we launch outbound commingling pools, will there be any implications? DS? I mean, is it a kind of place bet arrangement together with the overseas conductor? I understand your question. When we come up with the amendment, we try to focus on local bets on local and overseas races and the duty levy on those bets. When we discuss the matter with Jockey Club, we understand that for outbound commingling, there are certain special arrangements involved, but it doesn't mean that the Jockey Club will place any bets on to the overseas operators. So for this case, we're just talking about net stakes receipts on local bets, and we only levy duty on that amount. That's the whole focus of the bill. That means for outbound commingling, that is not related to bets. 6. Well, I want to talk about net stakes receipts. It's quite broad in your definition. Will it cover inbound commingling pools? For the inbound commingled pool, we first of all have to look at overseas bets on local races and to combine the local and overseas bets together to form a pool. For the current arrangements, progressive tax rates is only applicable to local bets. So for overseas bets, no duty will be levied on that. Mr. Liu? Another question about definition. I understand is about the transfer of bets. For overseas operators, they may see this as a kind of bets, but they will not affect your views, right? So it's actually about the managing of information on bets, right? When it comes to collecting betting duty and whether the jockey club makes a wrong move, wrong bets, and there will be law enforcement action involved. Now, in that case, we will have to ask the jockey club to supply information to us. And that's considered as a kind of information exchange, and it doesn't amount to betting. Just now, Mr. Alan Leung asked if this is the end of our task. The DS gave us explanation about the clauses, and we sat down a meeting at 10:45 on 3rd of June. That's our fourth meeting. At that meeting, I think they can answer the question raised by Mr. Alan Leung about the three definitions, whether they will be rearranged. And we can also go to the markup copy by then. We don't have to look at the sessions repealed, but we can look at the additions one by one at the next meeting. At the meeting on 3rd June, I hope we can complete our task, and by that time, the clerk will inform members when's the deadline for further amendments and when the matter will be taken to the council meeting. I don't think the representative from the Jockey Club should come to the next meeting, because we're talking about something technical. At the next meeting, we go to clause by clause. Chairman, Mr. Pang, can you consider this too? For specified payee, the definition goes like this. In relation to a right means the person who owns the right under the laws governing the rights. How many laws are actually governing the rights? Is it because there are so many that you skip to mention them here, or what? What we have in mind about the laws, we have in mind people who have to pay for the information related to the race and the songs or visual images related to the race. And the right to conduct betting. Now, we're not talking about someone from Hong Kong, but about someone overseas. So overseas jurisdictions, overseas laws come to the context. Chairman, I'm not saying that my question is absolutely justified. But we're talking about the laws in Hong Kong here. But you just now said that overseas laws are involved. In that case, I wonder if we have to go to the specific details here. betting duty may amount to a large sum, and court cases may be involved as a result. For overseas jurisdictions, they can always go for amendment, which will affect the effect of our amendment. I don't know if it's prevalent. Can I have a written reply? I'm worried. Because, say, for example, in Australia or even South Africa, if they amend their laws so that they can evade our betting duty ordinance, then there's nothing we can do. How much more time do you need for the reply? I'll be brief, Chairman. For the specified payee, it refers to N in the formula. If the amount is for the specified payee, then that is deductible. If the amount is not payable to the specified payee, the amount is not deductible. So we want to set down which amount is deductible. It must be an amount to the specified payee. This is for the sake of clarification and for the enforcement of our law. I think I need some time to digest it. Next meeting, June 3rd, 10:45. Thank you.